Good morning. This is Ken Middlebrooks. I'm the Chief Investigator with the South Carolina Department of Consumer Affairs. And today's presentation on our webinar is Physical Fitness, Statutory Requirements, and Compliance Issues. Today's presentation roadmap is going to talk about the history of the Act, who must file, requirements, and compliance review process. So the history of the Act. The Physical Fitness Services Act was first passed in 1985. The state had an influx of gyms offering lifetime memberships for very high prices. The gyms signed up a lot of members and then went out of business, leaving the consumers with no gym and no money. And as everyone knows, it's in the physical fitness industry, you can't offer lifetime memberships in the state of South Carolina. The maximum amount of time for a membership is 2 years. But the General Assembly passed legislation limiting the length of time of the gym memberships. They also created safeguards to prevent these problems from happening again. So who has to file? This is under our Physical Fitness Services Act, Section 447920, under number 1, physical fitness services means facilities or services for the development of physical fitness through exercise or weight control. The term includes the facilities and services of health or exercise centers, clubs, studios, or classes, health spas, weight control centers, clinics or studios, figure salons, tanning centers, and athletic or sports clubs. It does not include rehabilitative therapy administered by a licensed physical therapist, and that's a very important part of the definition. So who is exempt from filing? We touched on that last line of the last sentence of the previous slide. Also under Section 4479.110, the exemptions, the state of South Carolina and its political subdivisions and any not-for-profit corporations are exempt from the terms of this chapter. And one that jumps out is like the YMCAs. So for filing, and this would be for someone that would need to file for a filing package in regards to offering physical fitness services. You can find it on our website, and you can go to our homepage, and then you can go to licensing and physical fitness service providers. Under that website, you'll see the various laws, the licensing instructions and forms, which are your informative areas that you can click on that gives you your instructions of how to file and all the forms that would be needed for your filing package. And then we have various sample documents on there, some of what we'll be talking about today, but you can easily find those sample documents that you can use as a reference when you're creating your forms as well. Over on the side, you'll see where it says the icon File Online. It says Helpful Links. File Online is the first one where you can easily file through our internet service. And then we have over to the right the user guide for printing certificates for our various license holders, physical fitness being one of those. And you can see that in number 1 in our licensure gateway, and also number 2 in reference to your password and that type of thing to navigate your way through our website. And to touch on a little bit about the filing and this slide. So filers, we actually have where we have numerous centers that fall underneath our definition, open up all over the state and continually opening up new and continually one owner selling to a new owner. One thing, and we'll reiterate in another slide later on in our presentation, we need to remember that licenses are not transferable. So if you buy or if an establishment is bought from another owner that is licensed, that license does not transfer to the new owner. So a new filing would be required. But we'll touch on that and reiterate that again in various future slides. But the requirements for gyms offering membership options over 3 months in duration or costing over $200 must have financial responsibility in the form of a bond or a letter of credit. And if you're a personal trainer, if you're offering over 3 months in duration or $300 in cost, you must have a financial responsibility in the form of a bond or a letter of credit. And then the second part to that is a written contract must be done with a consumer if you fall into that category of a service being offered on your rate sheets. And it goes into our financial responsibility is dependent upon your number of members. So if you're 100 members to 99, one member to 99 members, it would be a $10,000 requirement for your financial responsibility, your bond or your letter of credit. 100 to 499 members, a $20,000 requirement. And then it goes on up the scale, 500 to 999, and then it tops out with 1,500 or more members, a $50,000 bond or a letter of credit. So what if a gym is just offering month to month? And in my years of being with the department, that's become more and more, where we don't have long-term contracts where offered a lot, and then over the years we've seen where it's just month to month with an ACH draft. So what if my gym is just doing month to month? Well, gyms that offer membership packages less than the $200 requirement or shorter than the 3 months do not have to have financial responsibility or use a written contract. A true month-to-month contract does not require a 30-day notice to cancel. It's truly month-to-month and can cancel at any time. However, we do know that banks require with ACHs, there's a 30-day cancellation in regards to doing that. And so we've seen that migration to where they say it's a month-to-month, but they require a 30-day notice to cancel. Well, that's technically a 2-month contract because the department perceives that a true month-to-month can cancel at any time. So now I'm going to go into what is the requirement if you do meet the parameters of needing a physical fitness service contract. And I'm going to let Joni go over those contract requirements.
So if you do trigger the need for a written contract, these are things that have to be on your contract. Number one, they have to be in writing, and the consumers must be given a copy at the time he or she signs it. If you are using electronic contracts, I know a lot of gyms are kind of moving towards that where they use iPads and stuff. It's fine if you email it to the consumer. If it's all electronic and that's how they want it to get it, doesn't necessarily have to be printed out, but you just have to give them a copy of it. The contract must have the address or the location of the gym, the center, the outlet that are included in the membership. It must clearly disclose any finance charges, and it must contain the consumer's right to cancel language stated in the statute. And I did a little screenshot there that just shows the right to cancellation. And that language is on the sample contract on our website. I know it's kind of small there, but you can find it on our website. And also this webinar, it should be available as a PDF in the handouts in your little GoToWebinar box. And I think they're recording it, so this should be available as a YouTube video later on down the road if you want to come back and check something. So get back to the contracts. Licensees that offer the long-term contracts must use one that is substantially similar to our sample contract on the department's website. Again, I just kind of screenshot what they look like, but you can pull it up yourself online. It doesn't have to be formatted exactly like this, but it does need to look basically like this. Obviously, you can put your logos, you can use your own font and make it pretty or whatever, but at the end of the day, it needs to look pretty much like ours. If you have questions about it, obviously you can always send it to us and we'll be glad to look at it. But all of the stuff on here needs to be on your contract as well. And you're welcome to take the one off our website and just put your name on it and use it. That works too. I'm going to go over some of those disclosures that's on our contract and just kind of talk about them and explain why they're there and why you have to use them. So the first thing on there, kind of at the top of our contract, we have a disclosure that shows the date of the contract, the type of membership, the beginning and ending dates, and the facilities included. So right there, we want to know the date of the contract so that you can see, if it's a 12-month, when did it start? when does it end? What type is it? A 12-month draft? Is it a 12-month paid in full? Is it a 24-month draft? Just so the consumer knows exactly what it is that they're purchasing. And then you have another line there that can show what gym's included. If you have more than one location and it includes both of them, if it's just for this address, just so the consumer knows exactly what they're getting. The next disclosures on the contract are the truth in lending blocks and the payment schedule. So these are required, these are federal requirements through Reg Z. So this isn't something that we're putting on there because we think it's fun, it's just federal law requires it. And this was one of the questions we had emailed to us earlier. The gym owner wanted to know what APR he should be using on here for this disclosure. And really that's going to be determined by your membership options. The truth in lending, you create an APR when you have a like a paid in full membership and a installment membership that have different rates. So just to keep math simple, if you offer a 1-year paid in full for $1,200, which is basically $100 a month, but if someone's going to make payments, if they're going to do it monthly, you charge them $120 a month because they're paying it over drafts. That difference in the amount between the paid in full and the installments creates a finance charge, and that's what you would enter in these blocks. So the difference in whatever that math is, 120 times 12, and then the 1,200, I think, what is that, $1,440 minus 1,200, that gives you a finance charge of $240. So that's what you would put in the second block there where it says finance charge. And then we have financial calculators. There's tools online you can use that would create or would give you the accurate APR for that. So those are the numbers that you would fill into those blocks right there. A lot of gyms choose not to have membership packages that create APRs. And one way to kind of, if you don't want to figure out all the math, is just have membership options in different lengths. So if you have a 12-month paid in full, maybe offer an 18-month draft, because now those membership options have different lengths or different durations, and we wouldn't compare the two charges between the paid in full and the installment. That kind of gets you around having to do all the math. But you know, some people, they don't mind doing the math. Once you figure out the numbers, you just plug it in over and over again for your contracts. So if you have questions about that, we'll be glad to talk to you one-on-one, but really it's based on your membership packages that you offer. The payment schedule down at the bottom, basically that's just going to show how many payments the consumer is obligated to pay and how much the payments are and when they start. Again, this just makes it really clear so everybody knows how much they're paying, when the payments start. If it's a paid in full, you can just strike through that disclosure and just write like PIF on it or paid in full or NA through both of these actually, just so that the consumers know that these are not really relevant to their membership. These are more toward the installment folks. The itemization of amount financed. This is kind of another way that the truth in lending blocks are disclosed. It's going to be the same numbers. And we can show you if you do have a finance charge and you do need to fill this out, we can show you how to figure out what number goes where. It's just another way really to restate. Some people are visual, some people are more word. So I guess this gives it in both ways to kind of hit both groups of people. Again, this is a Reg Z requirement. This isn't something the department has made up. This is just a federal disclosure that has to be on there. A lot of times people tell us that, you know, they're just joining a gym, they're not buying a car. Why do they have to have all this on there? But under the federal truth in lending, an installment contract is an installment contract. It doesn't matter if you're joining a gym or you're buying a car or, you know, what it is you're buying. The contracts are all the same and they have to have the same requirements. The time price differential statement, this goes back to, you know, if you are offering those paid in full memberships and installment plans that have the same duration, you have to have this on there so that you can show the consumers and they understand that they can either pay the cash price, which would be the first line, the first box up there, or they can use, they can choose to pay through installments, which also has a finance charge. This is, again, it's another disclosure to make sure they understand that the paid in full is one price, the installment is a different price, and it costs a little more to make payments. So if you don't offer memberships that have the same duration for a paid in full and installment, you don't necessarily have to have this on there. But usually I tell new gyms to go ahead and put it on there, because even though today your membership options aren't like that, you know, people change the prices of their plans with how their business is running. And in the future you might. So instead of reprinting a bunch of contracts, if you go ahead and put it on there, it's a very simple thing to, you know, strike through if you're not going to use it, but it's there if you ever need to. So you might as well go ahead and put it on there so you don't have to change it later. So like Ken said earlier, the legislators back in the 80s, they did offer some safeguards to keep from having the problems that they were having back in the 80s. And one of those is that you cannot have a membership that lasts longer than 24 months. You cannot have any kind of provision on the statute that waives the consumer's protections. You also can't have anything on there that says that, hey, if I assign this to a third party, it waives the provisions. So if you, you know, if a gym goes out and you sell all your memberships to the guy across the street, he doesn't get to now waive all of the protections of the state statute just because you sold him your contracts. And if there is anything on the contract that doesn't comply with the state statute, it's unenforceable against the member. So basically, there's no need to put stuff on there that is prohibited, because we're not going to hold them to that anyway. And I know a lot of this seems like it's all for the consumer and it's not business friendly, but I like to tell gyms when I come in to do advisories that there is a lot on here that are consumer protections, but it's also a business protection, because if you have everything on there exactly right, if you have the beginning date, the ending date, you have the type of contract, you have the payment schedule, if all that is on the contract and it's disclosed correctly, there's really no argument for the consumer to ever come back and say they didn't know what they were getting into and try to get out of the contract. It's just, you know, this document makes it very clear between you and your consumers exactly what you're willing to get and exactly what they're willing to give, what they're willing to pay for it. So it makes it just very clear for everyone. And so it is a business protection as well. There are some permissible contract provisions that you can put on your contract that you don't necessarily have to. There is a extension for a temporary disability or pregnancy. So, you know, if a consumer breaks their leg and they can't use the gym for 3 months, if you want to put a medical hold on the membership, basically you just pause it where you don't draft it, they don't come in and use it, or if it's like a paid in full, you give them 3 months after the expiration date. That's something you can provide. A lot of times that's kind of a selling feature for some gyms to talk about that. You can say that the contract is the entire agreement. There are some different renewal options that you can provide if you want to. So, you know, if you want to have them opt into those renewal options once the original contract expires, there are 2 different options there. And also you can say that the cancellation, if you do have the automatic renewals, that if they cancel the original contract, obviously that cancels the renewal. These are not things you have to put on your contract, but if you want to, you can. The next thing we're going to talk about are annual reports. So each year you have to file with the department. The certificates are valid from January 1 to December 31st. But kind of in the middle of the year there is a requirement to submit an annual report. They are due by June 30th. And basically this is just making sure that the department knows that the gyms are still in good financial status. The forms are available on our website that Ken showed y'all at the beginning of the presentation. I think you can do it electronically also, or you can print it out and send it. It's not as detailed as your renewal, but it just kind of gives us a snapshot of how healthy the industry is. Like I said, the renewals are every year by December 31st. Normally, I think our licensing program sends out a renewal notification maybe toward the end of October, and I think that renewal period starts November 1. So, you know, typically we get a lot of renewals between November 1 and December 31st. If you realize that you're getting toward the end of December and you normally mail it to us, I think they look at the postmark date there. or, you know, obviously you can do it online. And they'll give you a day or two, probably in January, to get it in with the holidays. But really, if you could get it in before December 31st, that would be best. So Ken and I now, I guess, are going to kind of tag team these. So we just want to talk about things you can expect during compliance reviews. So an investigator may come out to your gym for a compliance review. It could be in person, or we could contact you through a letter, an email, or even a phone call and tell you that we're, you know, interested in doing a review. Sometimes we call and set them up. Sometimes we just show up unannounced. So don't be surprised if you haven't heard from us and we just show up on your step one day, or, you know, we could send you a letter in the mail and let you know that, hey, we're going to start a desk review. We do them different ways for different places, and just, you know, how it fits into our schedule. So while we're there, we're going to ask for your membership options. So the pricing, what you charge to join your gym. We're going to ask for a copy of the current membership agreement. We're going to want a sample that we can keep. And we're also going to look at ones that have been completed. We're going to look at, you know, some of your active members. We might ask about your current advertising to see how you're marketing your gym. And then anything else that might be necessary to comply with the reg. So, I mean, receipt books, ledgers, really, if there is something that if we have a question about, we're not clear, we can, you know, really ask for any financial document. And it's just something I like to clear up kind of on the front end. We do get pushback sometimes from gyms that don't want to share that with us, but we are the regulatory authority over gyms in the state, so we are actually the ones that should be looking at that.
I'll add to that. So we had Investigator Robert Johnson that was going to do this presentation. He does a majority of the physical fitness reviews. Also, Investigator James Breeden is another one that does a majority of our physical fitness compliance reviews. Also, I will, Joni mentioned the word advisory. So if you're a new gym and you are just wanting to learn pretty much what we're talking about in this webinar, and have an investigator come and do an advisory visit with you, it's not a compliance review. We would not note any issues that we saw in regards to deficiencies in regards to like your contract. We would just go over what the statute and reg requires and kind of get you off on a good foot of an understanding, especially if you're trying to look through the laws and the regs and understand what your requirements are and you're still struggling. You're welcome to give us a call or send us an email, reach out to us, and we will come do an advisory visit. Also, when she touched on the bullet point in regards to advertising, there are several things that we discuss in regards to advertising that will be gone over in your compliance review, such as if you're advertising or promotions, if you're using the word free in regards to advertising. Also referrals, like a member referring somebody else, if you have some type of referral type of promotion. These are things that we would go over with you that are requirements, even Federal Trade Commission requirements that we would want you to be knowledgeable on.
Great, thanks, Ken. Some more tips for compliance reviews. If you can keep your files in a central location and in a searchable order. So it used to be back when I started, they were still paper contracts and we would go stand in the file room and look through folders. I know a lot of folks keep them like scanned now or electronic, but you know, if there is a centralized folder that we can come and click through and look for, or look for membership agreements, or if there's, you know, some way for you to be able to sort through them. Just some way that, you know, we can find a 12-month paid in full, a 24-month paid in full, a 12-month draft, whatever your different options are. We're going to want to see samples of filled out executed contracts for each of the membership options that you offer. Also, so that is the language there under Don't Shoot the Messenger. That is the provision under the regulation that says that, you know, all books, records, and contracts must be available during reasonable times for anyone from the department to come in and look at. And, you know, failure to allow access to that, it would be a violation of the Physical Fitness Act. Also, I just wanted to mention that we are not a punitive agency. We don't come in and find a bunch of problems on your contract and just start issuing like financial fines or penalties. We'll work with the gym to get them in compliance. You know, if we come in and your contract's just completely bonkers, it doesn't have anything on it's supposed to, we're going to work with you. We're going to show you what you need. We can help create an addendum that you can use with the current contract you have that has the disclosures you're missing. We can show you how to fill it out. We want you to be successful and we want you to do things the right way. So we'll help you any way we can. So, you know, don't look at us as the enemy when we come in. We want to be friends and help you do things the right way so you're successful. So also as a kind of a note to that, if you do have an issue with a consumer, if they're like billing issues, if they're a troubled consumer, if it's somebody that's always giving you trouble, that wants to cancel, doesn't want to cancel, rejoins, whatever. If you know, if you have something going on with somebody, make notes in the file, because a lot of times those are the ones that we're going to come in and ask you about because stuff looks wonky on the contract. You know, we're going through, we're looking at stuff, we see a contract with, you know, this really thick, has a lot of disclosures in it or a lot of contracts. We're probably gonna pull it, I'm not gonna lie, and we're gonna look at it and we're gonna want to know what's going on with that one. Like, why do they have 4 different membership agreements in this one file for, you know, 6 months? And it could just be that the person changes their mind a lot and you have a lot of, you know, back and forth with that person, but just make notes in there because we might ask you about that one, or sometimes those are the people that file complaints. So just make notes in your files about that. I know this is one that Robert checks a lot when he's out in the field, to make sure that your current certificate of authority is posted. He really wants to make sure that everybody has their valid certificate posted and not last year's. So I know that was something he was going to mention. Some more tips. Again, this goes back to the contracts have to be able to be printed. So even if you are doing the electronic ones, it's fine to email that to the consumers for their copy as long as they have a computer and a printer if they want it to print it. If not, if it's, you know, somebody without a computer or just doesn't want to go through the trouble, you do have to be able to print it from your software and give them a copy of it. Personal trainers, we talked a lot about the difference. You know, personal trainers, they do have a little higher threshold on the amount they can charge before they use a written contract. Some gyms have personal trainers that are on their payroll. And if that is the case, if I run Main Street Gym and I have a couple personal trainers that work for me, they are covered under my certificate of authority. However, some gyms will let personal trainers come in and work out their clients at the gym and they don't work directly for the gym. And if that is the case, then that personal trainer needs to have their own certificate of authority. So basically we follow the money. If the gym takes all the money and pays the trainer, they're covered under the gym certificate. If the consumers pay the trainer directly, then they must have their own certificate. Certificate of authorities are not transferable to new owners or for different physical locations. So if it's September and you're selling your gym to somebody new, that new owner needs to go ahead and file for their own certificate of authority. Yours doesn't cover them. And if you move from, say, Main Street to Elm Street, you need to let us know so that we can change that. It's not necessarily a new filing, but we need to go in and amend our records to show that you're now at Elm Street, and that would be the address on your certificate of authority. One of the automatic renewal provisions, if you want to do the automatic renewal, this is one I know Robert checks a lot. It is required to be on the first page of the contract in bold type and at least 14-point font if you're going to offer it. So just make sure if you're going to do some of those auto renewal options that you are cognizant of the requirements of those. Keep in mind things, the reviews can be random. They could be complaint driven. It could just be that we're in the area and we drive by. Typically, it's not something that we'll be doing every year unless there is a reason. You know, if the contracts are completely out of compliance and we work with you to get them back right, we might show up next year to make sure you're still using those. And sometimes it just works out that, yeah, your card gets pulled, you know, in 2 years instead of 3. but we can show up at any time, but typically it won't be something that we're there every year. It's a couple years between reviews. The department would rather be proactive than reactive. So if you're making changes to your membership options or your business model and you have a question or concern about a contract, or if you need a contract or how to fill out the contract, feel free to contact us. We would rather help you get it right on the front end than have to fix a lot of stuff.
I'll add also, when we come out to do compliance reviews, we're just pulling a sample batch of your contracts. So don't think we're pulling every contract. It's usually a very, very small percentage sample of just a handful of your different, if you give us a rate sheet, we're going to pull a handful of the different various rates, just so there again, we can go back and compare to see if you have possible finance charge of the difference between cash and installment, or some of the other programs. But please don't think that we're pulling all your contracts. It's just a sample form compliance review, because normally what we can find in a sample, a small percentage sample, we can point it out to you to show of how you need to correct if there's any deficiencies.
A lot of times when we're out in the field, when we're at a gym, they'll ask us, what about a guy down the street? What about the unlicensed people? How do we address that? And we do it a couple different ways. One way is that we do typically ask when we're in your gym if you know of any new gyms or personal trainers in your area that might have just opened up that didn't know about the need to file. So, just conversations we have with our gym owners. That's one way we find it. Through our daily activities, us just driving through towns, a lot of times, we know what gyms have been there forever. We know the guys that have, been in the business a long time. And then we see the bright, new, shiny new ones that are popping up, and we just stop in and introduce ourselves and explain what we are and what we're doing. So that's another way we find unlicensed businesses. We get it through consumer complaints and also internet searches. When I'm in an area, if I'm doing physical fitness compliance reviews, I might just Google and see what comes up. We have a list of all the places in that area that are filed. And then if I see some new ones, I'll go and check on those just to see, what's going on with them. So those are kind of the ways that we try to find the unlicensed people. If any of y'all have any ideas of other ways for us to find it, we would love the tip. But right now, that's kind of how we handle it. So again, that was just talking about, if you do keep the contracts electronically, you must be able to print them if the consumer asks for a paper copy. So again, I just wanted to show you, kind of to reiterate, that this was, if you go to our website and you click on physical fitness, this is kind of how it brings up. There are links there for the law and the regs, all the instructions to file. Your annual report is on there also that you can download and fill out. And then under sample documents, it doesn't show it here, but under sample documents, that would be where the sample contract is that you can pull up and look at. If you have questions, here are the contact information. Catherine Hawks is our licensing examiner. She has been with the department now for a little bit, but she's newer. So she's been doing a really great job getting people licensed, getting the new ones licensed, and getting the information back to them. Deborah Lockhart, she's been here for a long time. She could probably do this webinar herself with her eyes closed because she knows all of it. So she's also a great resource if you have a question. There's Ken's number and mine. We are usually in the office on Mondays, and then we are out and about the rest of the week. So those are our desk numbers. If you call either of us, if it's not a Monday, probably just have to leave a message and we'll get back with you. But yeah, so if you have anything come up, feel free to reach out to us. And I think that is about it. So we appreciate you all joining us today. And we look forward to seeing y'all in the field.
Have a good day.